Namaste, I am Anil Goel from AAA Insolvency, and today I am delivering voice 4 from Voices from Courtroom, our new series. Today we are going to discuss a judgment which is very important regarding income tax matters, and the issue is, in this case, the judgment is from NCLAT, the appellate authority. It is, the title of the judgment is Devarajan Raman versus Principal Commissioner of Income Tax, Mumbai 1, and the judgment was delivered on 24th of May 2024. The applicant was the liquidator Devarajan Raman, liquidator of Kotak Urja Private Limited, and the respondent was Principal Commissioner of Income Tax, Mumbai. The facts of the case are that this Kotak Urja Private Limited was admitted into CIRP on November 18, 2019, and Devarajan was appointed as the RP, and the claim of the Income Tax Department, which was about 11.59 crore, was filed on January 2020, and it was admitted by the RP. Then on February 10, after filing of the claim on February 10, 2021, 90.4 lakhs of rupees was received as tax refund as per the Income Tax Department, but that tax refund was adjusted by the Income Tax Department against the outstanding tax demands. So the first is the filing of the claim, 11.59 crore. Then is the issuing a refund order of 90.42 lakhs subsequent to filing of the claim, subsequent to getting the claim admitted, and also during the CIRP. Then the company actually was into liquidation, and during liquidation this amount got adjusted. Then the RP filed an application for liquidation because of no resolution, so it was also the past, and the company, the order for liquidation was issued. Then RP sent letters to the Income Tax Department like to refund the adjusted amount during the liquidation proceedings. The Income Tax Department again filed a claim which is as reduced by this 95 lakhs. So they amended that claim, and they said that this much of amount is recovered. So therefore the amount is now 10.69 crore. NCLT dismissed the application filed by the liquidator because the liquidator first filed an application before NCLT. NCLT dismissed, and then the appeal was filed before the appellate authority. Now the applicant argued that the adjustment of tax refund during the CIRP period violated the moratorium provisions of section 14 of the IBC. It was improper set-off. The applicant also contended that the set-off was impermissible as it occurred before the liquidation order and without following the due process under section 52 of the IBC. Even if we have to say that this was secured or unsecured, that's not a question here. Now the respondents said that the moratorium expired once the company is into liquidation. The CIRP period actually completed. So the respondent also argued that once the CIRP period expired, therefore the set-off was done after the CIRP period expired, means after the application for liquidation was filed, and also when the order for liquidation was passed. The issue of secured creditor status was also discussed, that we are secured creditor. The Income Tax Department was saying that we are secured creditor as per the rainbow paper judgment. Legal issues involved in this case is whether the moratorium under section 14 of the IBC continued until the liquidation order was passed despite the expiration of CIRP period. So the first issue was when the liquidation application is made, no resolution is found, and the liquidation application is pending before the adjudicating authority, then in that case whether this moratorium is continuing or not. So this is one legal issues. And the liquidation order violated the moratorium provisions. No, see, this is the like the sections 14, section 52 was also discussed. The regulation 29 of liquidation process was also discussed. Various other judgments like Bharti Airtel Limited versus Vijay Kumar V. Iyer, that was also discussed. The state tax officers versus Rainbow Paper Limited was also discussed. Then because of the claim of secured creditor, the Paschimachal Vidyut Vitran Nigam Limited versus Raman Ispat was also discussed. So similarly, what exactly NCLAT said after considering all this? After considering all this, what NCLAT said was moratorium under section 14 continued until the liquidation order was passed, and that the set-off by the income tax department violated the moratorium. The refund order 90.42 lakhs is supposed to be handed over to the liquidator, and it is the adjustment or the set-off was improper. Therefore, finally it was directed that the liquidator will get this within 2 weeks' time from the department. So the clarity that this judgment is throwing, number one, that the duration and scope of moratorium under IBC, emphasizing that it remains effective until the liquidation order is passed. It enforces the procedural requirement of secured creditors to realize their interest, ensuring that such actions cannot bypass the established insolvency framework. This decision impacts how government authorities handle their claims in insolvency cases, ensuring that they are treated equally alongside the other creditors. Now, very important that NCLAT has passed this order to clarify that the income tax department cannot adjust refund orders with past dues. It is the entitlement of the RP or it is the entitlement of the liquidator, and it has to be given to them. The judgment is very important. It clarifies, and various other such litigations will actually come to an end. Thank you very much. Please do subscribe so that you get alert for all our voices from courtroom. Thank you.